This presentation explores special services and students with disabilities. First, let's look at what special services are. Schools mainly follow two laws in regards to special services and students with disabilities. The first law is IDEA, or the Individuals with Disabilities Education Act. This is an educational benefits law. In order to qualify to receive services under IDEA, students must meet one of the 13 disability categories. These categories are specific learning disability, other health impairment, autism, emotional disturbance, speech or language impairment, visual impairment, which includes blindness, deafness, hearing impairment, deaf blindness, orthopedic impairment, intellectual disability, traumatic brain injury, and multiple disabilities. Once a student qualifies, they are given the right to receive services that are individualized and outlined in the student's IEP. All teachers that are responsible for serving this child must sign the person's responsible form of the IEP. This form requires that all teachers who see the student will provide the appropriate services that are outlined in the student's IEP. IDEA mandates that eligible students with disabilities are given a free appropriate public education, or FAPE. The other law is Section 504 of the Rehabilitation Act. This is a civil rights law. Section 504 prevents discrimination based on disability. Students who qualify are given accommodations to ensure full access to the curriculum. Like IDEA, Section 504 mandates that eligible students with disabilities are given a free appropriate public education. So why should educators have knowledge on this topic? According to Cooper, more than 6.8 million children ages 3 through 21 receive special education and related services each year in the United States. With that number, educators should obviously have an awareness of the legal rights of students with disabilities. Also, special education services are a legal right to eligible students. So it's very important for educators to understand due process and adhere to it in regards to students with disabilities. Due process is guaranteed with the 14th Amendment of the Constitution. This amendment protects the rights to a public education for all students. The Due Process Clause says that states may not deprive any person of life, liberty, or property without due process of law. A due process complaint can be filed for a dispute that is related to identification of a student, evaluation of a student, the educational placement or the least restrictive environment of a student with disabilities, or an issue with the provision of FAPE. All disputes lead to a decision which can be challenged in court if one of the parties does not agree with the outcome. So now let's look at 3 current legal cases that impact special services and students with disabilities. The first case that we'll look at is Evans versus Antioch Unified School District. The second is a very well-known case currently, Andrew F. versus Douglas County School District. The final case that we'll look at is Fry versus Napoleon Community Schools. The first case is Evans versus Antioch Unified School District. This court case was decided by the U.S. District Court in California in 2013. First, let's look at the facts of the case. Alan Callboy was a teacher in Antioch Unified School District. She was accused of verbally and physically abusing 8 special needs students. Some of these students were as young as kindergarten age and nonverbal. The students were African American students, and Alan Callboy had been observed numerous times using racial slurs. The school district was notified of Alan Callboy's behavior by multiple parents on multiple occasions. The school district failed to act on the reports. They did not report abuse suspicions to the authorities. This case was settled for a record of $8 million. To date, this is the largest settlement in a special education case. There are several significant factors of this case. First, Alan Callboy violated the student's constitutional rights because she used unjustified and unreasonable force with these students. Also, the school district was liable for failing to act on the numerous reports that were given to them by these parents. This case is very important, and it stresses the importance of school personnel receiving certified restraint training. Those who are certified in restraint training learn that it should only be used as a last resort. This court case should also show teachers that unless they are trained on certified restraint, then they should not ever put their hands on a student. The next court case is a very popular court case currently. This case is Andrew F. versus the Douglas County School District. This court case was decided by the U.S. Supreme Court in 2017. First, let's look at the facts of this case. Andrew F. was a 5th grade student with autism in Colorado. He was placed in a private school by his parents because they did not believe he was making adequate gains towards his IEP goals in the public school setting. Andrew's parents sued the school district because they wanted to be reimbursed for the private school tuition and related expenses. IDEA mandates that if a public school cannot provide adequate services to a student with disabilities, the student may enroll in a private school at the expense of the public school. This case took several turns. First, they went before an administrative law judge, and their case was rejected on the basis that the public school did provide a free and appropriate public education to Andrew. After that, they went to the district court. The district court also rejected their case because his parents didn't prove that a free, appropriate public education was not provided to Andrew. After that, the parents went to the U.S. Court of Appeals, and they also affirmed the decision that was made by the district court. Finally, the Supreme Court unanimously decided that Andrew's parents should be reimbursed. This case was significant for a couple of reasons. First, the U.S. Supreme Court ruled that IEPs must give students with disabilities more than a de minimis or the minimum standard of education. According to the U.S. Supreme Court, students with disabilities should be challenged too. Educational programs also must be reasonably calculated to allow students with disabilities to make sufficient progress in the classroom. This court case was a huge win for students with disabilities because it mandated that they be challenged in the classroom just like every other student. A final court case that we'll look at is Fry versus Napoleon Community Schools. This court case was decided by the U.S. Supreme Court in 2017. Let's look first at the facts of this case. E.F. was a student who was born with cerebral palsy. She was prescribed a service dog to help her complete everyday tasks, such as opening doors and picking up objects. E.F.'s school would not allow her to bring her service dog to school. Instead, the school provided her with a human aid, as outlined in her IEP. E.F.'s parents sued the school administration and district because they violated several state and national disability laws, such as the Americans with Disabilities Act. The district court did not side with EF's parents because they said that they did not do the appropriate steps in due process. This case was very significant, though, because the U.S. Supreme Court found that the lawsuit could not be dismissed because the parents failed to exhaust the IDEA administrative remedies, which are due process, since the claims were not based on a denial of FAPE. Because EF was not arguing that she wasn't receiving a free and appropriate public education, the Supreme Court found that this case should be looked at again and not dismissed by the district court. This decision enables students with disabilities to enforce judicial rights without first going through due process, which can be very time-consuming. All of these court cases show the importance of teachers understanding the legal side of students with disabilities and special services. This is a list of references that I used to complete my research. Thank you.